Next, we're going to talk about ADR. Alternative Dispute Resolution, or ADR for short, is the common name for many of the different ways of settling a disagreement without suing in court. ADR includes mediation, arbitration, neutral evaluation, special masters, referees, binding arbitration, and settlement conferences. The most commonly utilized forms of ADR are settlement conferences, mediation, and arbitration. You may be asking yourself, can I settle my case without having to go all the way through the case process to a trial? Yes, you absolutely can. You can utilize the ADR services that are offered in your area. Let's talk a little bit about what types of ADR are available. Mediation is where there is a neutral third person, the mediator, who facilitates communication between parties to help them reach a mutually satisfactory agreement. In contrast, arbitration is when there is a neutral third person, the arbitrator, who listens to both sides of the case and makes a decision or an award similar to a judge. As well, there is settlement as an option. At any time, the parties can talk to each other and come to an agreement to resolve their case. You may be wondering, what are the advantages of ADR? ADR can save you many resources, including time in court or away from work, money in court costs and attorney's fees, and the energy of conducting a case and having the stress of a case. With ADR, you are also more involved in your case and in control of the case. You control the pace, and you're involved with the process all the way through. As well, ADR can preserve relationships between parties. ADR can also be kept private, whereas cases in court become part of the public record. Most importantly, realize that you do not lose the opportunity to file or sue in court if you can't settle using ADR. The only way that could happen is if, while you are using ADR options, you allow the statute of limitations time limit to run out before you have filed your case in court. Let's talk a little bit about what you can expect in a mediation. Mediation is going to be an opportunity to meet face-to-face with the other party and discuss your situation while having a trained neutral person there, the mediator. The mediator will have no decision-making authority, and unlike a judge or an arbitrator, a mediator will not decide what is right or wrong or make suggestions about how to resolve the problem. The mediator does not take sides or push for any one solution. Rather, the mediator maintains a neutral role. Mediation will help you focus on the future instead of the past, and what will resolve the conflict. Remember that mediation does not replace the need for legal advice or counseling. However, it is an excellent way to resolve your case without having to go through the lengthy court process. If you have a small claims case, let's talk a little bit about how mediation can work in your case. You may be able to schedule mediation in your small claims case either before your hearing or even before filing your case. In some counties, mediation is also available on the day of the hearing. Something that many people wonder while conducting their case in court is, how do I address others in my case? Let's start with how you address opposing parties. The opposing party is the other person in your case, the person that you have sued or who has sued you. If both of you have an attorney, there are some particular rules of professional conduct that apply to those attorneys. However, the parties themselves, you and the other party in the case, are always able to talk directly to each other, regardless of whether you have attorneys or not. This slide depicts how the rule works between parties and attorneys. You'll note that parties can always talk directly to each other, and attorneys can always talk directly to each other. Attorneys can always talk to their own client. However, they cannot talk to the other party without the other party's attorney's permission. You may also wonder, how should I address opposing counsel? That is, the other party's attorney. You always want to speak to this attorney respectfully, and it's very common for attorneys to refer to each other as Mr. So-and-so or Miss So-and-so. If you're unsure of whether to call them by their full name or first name, you can always follow the other attorney's lead. Finally, you'll want to know how to address the judge in your case. You will always want to refer to the judge as Your Honor. Do not interrupt the judge when he or she is speaking, and when you are speaking with the judge, be brief. As well, speak slowly and clearly. Also keep in mind that the judge must keep to a very busy schedule, so do not feel that you are rushed. Rather, remember, the judge is trying to hear everyone in the court that day. Once your case is in court, you'll want to be prepared for any court appearance that you have. There are a few things you can do to prepare for this. One is you can observe hearings ahead of time. They are open to the public, and you may sit and observe. This will show you what the judge is doing and what the parties and attorneys are doing during a court appearance. Anytime you have a court appearance, you're going to want to bring all of the papers that have been filed or served with you, as well as paper and pen. You also want to think about dressing appropriately, as your appearance can affect a jury. When you arrive at your court appearance, you will want to check the court calendar outside of the courtroom and remember your line number. You will then sign in or check in with the court clerk inside of the courtroom and sit in the audience until your line number is called. Anytime you are going to court for a hearing, you'll want to be particularly prepared. You want to review your pleadings, especially any motions or responses that were filed for that hearing. You'll want to have an outline of what you're wanting and a summary of why it should be granted. Then make sure that the judge makes orders on each of the items that were requested. Lastly, tips on appearing in a trial. Anytime you're appearing in a trial, you want to be professional. If you're handling your own case, you are being your own attorney, and you will be expected to act just as other attorneys would act. Keep in mind, the courtroom is not a place to be dramatic. It is not like court you see on TV. Instead, you want to be prepared and be brief in making your points. As well, keep in mind whether you are addressing the judge or a jury. Thank you for watching. If you need more information or have other questions, please consult with an attorney.